What's up, everybody? Welcome back to another episode of the Lawyer You Know podcast. And today we're going to be breaking down the appellate decision in Letecia Stauch's case. If you remember this trial, we covered it together. It was one of the most gruesome and horrific trials we've ever covered, as she was convicted of ending the life of her 11-year-old stepson, Gannon. It was just disturbing and just absolutely disgusting, the entire trial, what she did and what the state proved beyond a reasonable doubt. But one major mistake by the prosecutor in jury selection has cost them that guilty verdict. It has been overturned by the appellate court. And now they're going to have to do this trial all over again unless they decide to appeal it up to a higher court, which, based on this ruling and based on the laws of this state, I don't think they've got a shot. So let's break down this order and figure out what happened at trial, how they can do it better in the second trial, and how this can be a lesson to all lawyers, especially prosecutors, about getting the job done right and why it's so important to follow all the rules so that when you get a conviction, it's secure and we're confident that it's going to hold up through appellate scrutiny. All right, let's get to it. One of the things I love about the law is there's always opportunities to learn. And really good lawyers make mistakes. Really good judges make mistakes. And when you do, that's why we have checks and balances. And as lawyers and as judges, we should welcome and celebrate these checks and balances because we are not the end-all be-all. We all are very confident. We try to do our best. We try to make the right decisions. We try to apply the facts and the law appropriately. But sometimes we get it wrong. Sometimes we get it wrong in arguments. Sometimes we get it wrong in decisions. And I remember when I was at the state attorney's office one time and I went to trial very early on. I think it was like the second trial I ever had. And I was for sure trying to fit a square peg into a round hole or whatever the saying is. And I just wanted to win. And I was arguing all different things to finagle past JOA, a judgment of acquittal. We got past that, jury convicted. Later, that was overturned on appeal because it just wasn't the right fact pattern for the crime that was charged. I didn't decide the crime that was charged, but I did decide to go try the case because I was trying to try every single case I could while I was there to get as much experience as I possibly could. So it happens. And I'm coming from a place where I understand when you get in the heat of battle and you really think you have the guilty party, you have the person that has done this to her 11-year-old stepson, and you want to make sure you convict her. So you're arguing everything. You're trying to win every legal battle. And sometimes really good lawyers can create problems with how good they are at arguing and convincing the judge that they are right and to do what they think is the appropriate thing to do. And so even though, and another way this is a learning experience is through that trial, Letecia Stauch seemed like one of the most evil people we have ever covered a trial of. And that's saying something, right? And because the judges, the appellate judges, felt like something went wrong and this was not a just and fair verdict because of the rules that were broken, they overturned that verdict. Even with overwhelming evidence and a pretty clear guilty defendant, this is highlighting what I keep saying, that the justice system has to work for the worst of us. And many of you, I think, would say Letecia Stauch is the worst of us if it's ever going to work for the best of us. And most of us think we are the best of us, right? I know better. I know I'm not the best of us, that's for sure. But my friends, family members, we want it to work for us and for everybody that we love and everybody we care about. So it's got to work for Letecia Stauch if it's going to work for us. And this highlights that fact. And this should make you, I know how horrible people are going to feel. Tell me how you feel in the comments. And you can be honest. I know how you're going to be feeling when you heard that this verdict was overturned. Okay? And I understand that. But when we read through it, you should actually gain more confidence in our judicial system. You should gain more confidence that the people that are convicted, that we get it right. And if there was a problem, the appellate court actually is looking at this. They're not just rubber stamping when it's the generally bad gal like Letecia Stauch. They want to make sure even Letecia Stauch gets a fair trial. So I hope that you can at least find some solace in that. I understand how devastating it is to think about it for the victim's family and all of the witnesses in the community and everybody that might have to go through this again. All right, so here we go. People v. Stauch, criminal law, structural error, waiver, invited error, jury bias, challenges for cause, peremptory challenges. Okay, that's kind of some of the marks we're going to be hitting here. A division of the Court of Appeals considers whether an erroneously denied challenge for cause is waived or invited by virtue of the fact that the defendant does not use a peremptory challenge to remove a biased juror to correct the trial court's error. So they said a lot right there. And we've talked so much about jury selection. and about how difficult it can be and how many hoops you have to jump through as a defense attorney when you want to strike a witness. You have to argue that they're struck for cause, meaning they cannot, just legally cannot be fair and impartial. And if a judge doesn't agree, later you can use a preemptory challenge, which you can strike any juror you want for any non-discriminatory reason. Well, it seems like they didn't necessarily jump through all the hoops. And I didn't watch jury selection. I knew nothing about this issue. I didn't read the appeal. A lot of people like myself just assumed like, okay, they're going to find some things to appeal and it's probably going to get, it's probably not going to get overturned. Well, because we don't watch jury selection and we don't see some of these issues, we never know about these issues until something like this comes down. The majority finds neither waiver nor invited error in this context, and applying People v. Abu Natambu L. Concludes the error warrants reversal for structural error because a biased juror deliberated. The dissent concludes that the fact that the defendant waived the right to claim error on appeal by exhausting all of her preemptory challenges without excusing the biased juror. So the dissent, which is interesting, is more of what you see in where it's just like this person didn't like my client, or they probably knew too much, or we think that they're biased. But when we hear about where the quote unquote bias comes from this juror, you'll realize why the majority disagreed with the dissent. But the dissent is kind of the normal train of thought here, which it's like, if you didn't even try to use a preemptory challenge on this juror that you thought was so biased, how bad could they have been? Because we have opportunities as lawyers to pick the worst ones. And every situation has different number of preemptory challenges. I don't remember exactly what they had here, but they used them on other witness or on other jurors. They did not use them on this juror that has now been the subject of this case getting overturned. And there's two ways to look at that. Number one, if you're a defense attorney and a judge screws up, be like, okay, that gives me an appellate argument in my back pocket. I'm going to strike these other jurors because I tried to get this one struck for cause. And we don't want that. So that can be the danger of the precedent that this sends. But you'll see how specific this situation is and how it started with a prosecutorial mistake, ended with a judicial mistake or judicial error. But the prosecutor is the one that really has to make sure this doesn't happen again in the future. All right, so let's get to it. Defendant Letecia Stauch appeals the judgment of conviction entered after a jury found her guilty of first-degree M after deliberation, first-degree M of a child under 12 by one in a position of trust, tampering with a deceased body, tampering with physical evidence, and multiple crimes of violence and sentence enhancers. Because we conclude that the trial court committed structural error by denying Stauch's challenge for cause to a biased juror who deliberated, we reverse the convictions and remand for a new trial. So again, those very important things. Biased juror, they tried to exercise a cause challenge, and that juror deliberated. You're going to see a weird argument by the state about that deliberation here when we get into it. Background. The prosecution presented evidence at trial that Stauch brutally killed her 11-year-old stepson, GS, in Colorado, put his body in a suitcase, and left it underneath a bridge in Florida. Stauch had pled not guilty by reason of insanity, arguing that she suffered from dissociative identity disorder. And we remember. And so whenever you have these kind of not guilty by insanity trials, you never know how the evidence is going to be presented. You never know what a jury is going to do. Right? We've seen some death penalty trials where we for sure thought it was going to go one way and it went another way because they either felt bad for the defendant or they thought the mental health issues were overcoming, or we've seen some shocking not guilty by reason of insanity wins. Right? It's a small percentage that wins, but still it feels like a slam dunk, but nothing ever is in the law. But the jury rejected the defense and found her guilty as charged. The trial court sentenced Stauch to life imprisonment without the possibility of parole, plus 2 consecutive sentences for the 2 tampering convictions. On appeal, Stauch claims the court committed structural error when it denied her challenge for cause to a biased prospective juror who then deliberated. She also asserts the court erred by denying her request to suppress evidence obtained pursuant to an overbroad warrant and by admitting certain testimony by her ex-husband, GS's father. We agree that the court committed structural error when it denied. That just means that the trial cannot be fair when the judge commits structural error. When it denied Stauch's challenge for cause and a biased juror deliberated. As a result, her convictions must be reversed. Because it is likely to arise on remand, we also consider and reject Stauch's Fourth Amendment challenge to the search warrant. However, we do not reach the remaining evidentiary issues. The evidentiary issue. So basically, we're not going to go through her objection to the search warrant that they rejected that argument. But basically they said, we didn't think it was overly broad. We're just going to focus on the fact that this was overturned because of argument number one. That's going to be the important to take up what the video is on today. Section 1610-103 provides that a trial court shall sustain a challenge for cause on one or more of the following grounds: relationship within the third degree by blood, adoption, or marriage to a defendant or to any attorney of record or attorney engaged in the trial of the case. Seems pretty simple. This is the law of that state. And this word right here, shall. A trial court shall. Sometimes there's a may, sometimes there's a can, sometimes there's a could, sometimes there might be a should. I don't know if I've ever heard a should, but should is more like shall. Shall and must are the important words in this statute construction. They have no discretion. We talk about judicial discretion all the time. There's so many scenarios where judges have so much discretion. This is not one of those scenarios. They must sustain a challenge for cause on one or more of the following grounds. A relationship within the third degree. Okay, what does that mean? Well, 3 degrees of separation in your relationship to either the defendant or the attorney of record. That could be by blood, adoption, or the important one here, marriage. The existence of a state of mind in the juror evincing enmity or bias toward the defendant or the state, unless the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at trial. Jurors who fall within one of these categories are considered biased as a matter of law. That means you cannot rehab them. In jury selection, sometimes if a juror says something bad or something that we like for our case, like, I don't know, yes, I'll give money for pain and suffering. Or let's say a juror, this just happened to me. So a juror says, no, I would never give money for pain and suffering, even though that's what the law says, that's the only thing that you can do. Then the defense can come up and say, well, what if the law explains that because someone suffered pain, we don't live in a barbaric society, we live in a civilized society, so that's why money can be given for pain and suffering. Would you then agree, and would you be able to do it if that's what the law provided and that's what the evidence shows? And they're like, yeah, I guess I could. That's rehabilitating a juror who said something that would make them struck for cause because it shows bias and the inability to follow the law. So they would have been struck, except the other attorney was able to come up and rehabilitate them. These jurors that are biased as a matter of law cannot be rehabilitated. It's not like you can say, hey, the state attorney is my brother, but I'm not going to make him my brother or going to pretend like he's not my brother throughout the trial. You just can't do that. You can't rehab them. They're biased as a matter of law. Doesn't mean they're a bad person. Doesn't mean they wouldn't be a good juror. Doesn't mean they wouldn't be fair if they actually deliberated on the case. We just don't want the appearance of impropriety. We don't want this situation to occur. Impliedly biased under Section 1B and actually biased under Section 1J, unless they can be rehabilitated. You're not going to be rehabilitated if you're biased as a matter of law. Upon a challenge for cause, the trial court is required to excuse them because, except as described in subsection 1J, they cannot be rehabilitated. Okay? So I would be interested in what they actually think you can do to rehabilitate a juror like this. Because I've never seen this type of scenario when a state has this type of law, ever someone be rehabilitated, but I'm open to be wrong, right? And I'm open to somebody say, oh, we actually did argue it for this reason or that reason. Maybe it's like, I'm divorced and it was my sister's cousin. Maybe it's the 4th degree, but then they wouldn't fall within the statute. Or maybe it's the existence of a state of mind in the juror evincing enmity or bias towards the defendant. So maybe that is... maybe that is talking about this section can be rehabilitated. I've never seen a scenario where this section has been rehabilitated, but I'm open to people that have seen that been done before, and I would love to hear how. Upon a challenge for cause, the trial court is required to excuse them because, except as described in subsection 1J, they cannot be rehabilitated. In People versus McCrander, the Supreme Court held that when an elected district attorney is the attorney of record, section 1610-103-1B includes prospective jurors who are related not only to the elected district attorney, but also to any deputy district attorney in that office at the time of jury selection. This is why it's a very specific circumstance, a very specific case, a very specific situation here in the Stauch case. Because it was the elected district attorney This applies to any deputy district attorney in that office. So it doesn't just have to be in normal circumstances. And with most of this, it's, the assistant district attorney that's trying the case, it's their mom or their sister or whatever. But when it comes to the actual elected DA, that extends to all of their deputy DAs, according to this case. That is, the statute directs automatic removal of a juror related within the third degree to any deputy district attorney in the elected district attorney's office, regardless of whether the deputy district attorney appeared or participated in the case. So it's much more broad when you have the elected district attorney trying the case. This preserves the appearance, if not the reality, of fairness in a criminal prosecution and public trust and confidence in the criminal justice system. This seems simple to me. Frankly, even if it's not the district attorney and, there's a deputy DA trying the case and that person's married to a different deputy DA in the office, to me, that person should be struck. I've never really had a judge not do something that seems this obvious to me in trying a case on the criminal side or the civil side. And honestly, if I'm the prosecutor, I'm going to be like, yeah, okay. We get people struck that work in defense attorneys' offices or insurance companies' offices. They get people struck that work in plaintiff's attorneys' offices in my trials. This time of year, especially in Florida, it always makes me rethink what's in my closet. I'm trying to keep fewer things, but better ones. Pieces that are well made and easy to wear all the time. You can mix and match with different outfits, which is why I keep coming back to Quince. So thank you to Quince for sponsoring this episode. The fabrics feel elevated, the fits are great, and the pricing just works. Recently, I went back and got another pair of gym shorts. I got another kind of cool shirt that's going to be perfect for spring and summer. It's a short sleeve button down that I can wear opened or buttoned up. And it's just going to be awesome. And I can wear it in so many different scenarios. There are so few places you can go anytime you need to pick up a new piece for your closet. And Quince is that place for me. I even wore the bomber jacket I got from Quince during my TEDx talk. That's how much I like Quince. So refresh your wardrobe with Quince. Go to quince.com/LYK for free shipping and 365-day returns. Now available in Canada too. Go to QUINCE.com/LYK for free shipping and 365-day returns. Quince.com/LYK. When a trial court erroneously denies a challenge for cause and a biased juror serves on the jury, the error is structural and requires reversal. Let's get into some additional facts. As part of voir dire, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. Prospective juror M.B. indicated that his son-in-law worked with the El Paso County District Attorney. So here's what else I have to say. Kudos to this juror. He didn't lie. He didn't try to hide this. He didn't try to cover this up. He did nothing wrong. He's like, yeah, this is who I am. If you pick me, I'll do it. I'll do my duty. During follow-up questions, juror M.B. confirmed that his son-in-law worked as a deputy DA in the same office as and for Michael Allen, the elected DA in El Paso County and the prosecuting attorney in this case. Defense counsel later identified juror M.B. among the prospective jurors he wished to challenge for cause. When the court asked for more detail, defense counsel explained his son-in-law works for Mr. Allen. The prosecutor and court then made the following comments. Prosecutor, I hate to agree with defense, but the follow-up questions were never asked. How that's going to impact his ability to be fair and impartial juror, and that certainly doesn't rise to a level of statutory cause. So we would object to him being released for cause. So even he, it feels like, says, I hate to agree with defense. But the big mistake, they objected. That's the big mistake. And again, does not make this prosecutor was great. I thought he did an amazing job. I'm actually, again, I don't even know if he's still the DA there. I'm assuming that he is. But if he does try the case again, I thought he was a good trial lawyer. And you can see how it's like he's wrestling with this in his head. And again, to give grace to people, right? Because he's still trying to win. And he's like, I do agree, but we'll object and let the judge make the decision. But he shouldn't have objected. He should have just let this one ride and picked a different juror because I don't think it would have mattered. But it's easy to say that in hindsight. It's easy for people to read this now and say that, okay? But if you've tried a case, you know how many things are going on at once. You know how many things you're trying to do when you're trying to get justice. You're fighting in there for justice. And the court said, yeah, I'm going to circle back to that one too. Probably what I'm going to do is not excuse juror M.B. at this point in time and think about it over the weekend and see where we are. So Judge M from Richard's trial probably would have gone and read the statute. It doesn't seem like this judge did. I can't put my finger on, I can't remember this judge. I can't remember a ton about this judge. But I don't remember him being a bad one, right? Like a judge that we were like, oh, it's just so bad. I think he was probably a good judge. I feel like a lot of the judges we've watched these trials were good judges. I'm sure you guys will remember and remind me in the comments. I tend to agree that I don't think it's a statutory cause. And I didn't hear anything else about the fact creating an issue or conflict or something else. I don't run across these sets of facts very often, so I need to think about that one. And it may be that I decide it next week. So something the defense could have done, obviously, is provide the statute there. The prosecutor suggested the court ask further questions of Juror M.B. and the court agreed. Defense counsel objected. I think the record is what it is, and I guess the only thing, I think that there is, a difference between somebody saying I have a son or daughter who works for the police than I have a son in law enforcement who works for the DA who's actually trying the case. He's absolutely correct. And so I think that's where it becomes different. Even if it was a different DA. See, that's a little different, but that's not quite what the statute says, I don't think, but we don't need to get into that since it's not this fact pattern. Other than his son-in-law's direct boss, who is trying the case. I think it would be different, and I'll leave it at that. I mean, you can imagine, too. It's like, bro, your dad was on the jury and voted not guilty. Might not be good for your employee. Not to saying he would do that, but you just don't want those problems, right? The trial court brought the prospective jurors back and asked Juror M.B. how long his son-in-law had worked for the DA, whether M.B. had discussed the case with the son-in-law, and whether Juror M.B. might be influenced by a desire to have the case work out better for his son-in-law. Based on his answers, the court instructed Juror M.B. to return the next day. He was not ultimately dismissed. And I don't know if the defense continued to object, tried again to use a cause challenge. And obviously it sounds like based on the argument above, they didn't use a preemptory challenge on him, which they could have. And again, this is to say that nothing wrong with Juror M.B. He answered in a way that everybody was like, or at least that the prosecutor and the judge were like, okay, I think he can be fair and impartial. Discussion. The Attorney General does not dispute that Juror M.B. fell within the category described by section 1610-103-1B because he was related within the third degree to his son-in-law, who was a deputy district attorney in the prosecuting district attorney's office. We are bound by the Supreme Court's decision that his bias was implied by law. Nevertheless, the Attorney General argues that reversal is not warranted because it's not clear from the record whether Juror M.B. deliberated. That to me was like, what? They're not sure he deliberated? How do you not know if a juror deliberated? The Attorney General also asserts that the defense counsel's challenge for cause was not properly preserved and that counsel either waived or invited the trial court's error. We are not persuaded by those arguments. So that's the better argument, is that, yes, the judge erred, but the defense attorney's screw up was the reason the juror was not struck, and they could have fixed the judge's error, but they dropped the ball, and therefore they waived this opportunity on appeal. And this is one that has been a winning argument in different scenarios. I understand where the trial court or where the appellate court comes here, but I do think this is the better argument for the Attorney General. That sure, he should have been struck for cause, but the defense could have struck him with a preemptory challenge or asked for an additional preemptory challenge, which doesn't seem like they did, which usually you have to do to protect these issues for appeal. So that's interesting. And the trial court is not persuaded by the Attorney General arguments. So let's talk about the deliberation. Our review of the record demonstrates that Juror M.B. deliberated. Indeed, the trial court granted Stauch's motion to settle the record on this point, removing any doubt. While the Attorney General dismissed portion of the record as new material, the trial court's order settling the record was accepted as part of the supplemental record on appeal. It is therefore properly before us. I don't get it. I don't understand what the dispute is, obviously, because I didn't read appellate arguments. I don't understand what the dispute is here as far as whether or not M.B. deliberated. That seems like it should be pretty cut and dry. And it seems like the trial court agrees because they said, we're removing any doubt. The juror M.B. did deliberate. And the appellate court also is like, yeah, we're not even really going to talk about this argument because it seems simple. Also, kudos to the trial court judge who, like I said off the top, should welcome, expect, and appreciate checks and balances in making sure we get the right decision and we get justice. Because the trial court could have been like, oh, I don't know if juror M.B. deliberated. Obviously, there's some kind of argument that the Attorney General made in good faith. And the trial court could have been like, yeah, we're not really sure, but he didn't. He put that to rest and said, no, juror M.B. did deliberate. The challenge is properly before us. The Attorney General first argues that Stauch failed to properly preserve her challenge for cause because counsel did not explicitly cite Rule 1610-103-1B and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than a statutory ground. The Attorney General further asserts that defense counsel's comments after making the challenge for cause suggest that the challenge was based on juror M.B.'s actual bias subject to rehabilitation. Okay. And see, that's the issue, right? And that's what we were talking about, how I think one, you can rehabilitate, one, you cannot. Not his implied bias based on his relationship to the prosecutor. For the reasons discussed below, we conclude that the trial court considered and ruled on a statutory challenge for cause under section 1610, 103, 1B. Therefore, the challenge is properly before us. The footnote says the Attorney General frames their argument in terms of preservation, which directs our standard of reversal, but structural error generally requires automatic reversal without regard to whether the error was preserved. Nonetheless, in order for us to review the erroneous denial of a challenge for cause must have been made. And we recognize the defense counsel's challenge for cause potentially implicated two different subsections of 1610-103. Recall that the statute requires the court to sustain a challenge for cause on one or more grounds, including implied bias based on a relationship of an attorney of record, subject to 1B, and actual bias subject to rehabilitation, subject 1J. Okay, yeah, so that's where they're saying that and every state has the statutes written a little bit different, but they're confirming here that you can only rehabilitate on the 1J, not the 1B. That is defense counsel's, by the way, in case you can't tell, this is the first time I'm reading through the entire appellate argument. I read the initial part before of why they overturned it, and then just applying how this stuff works. It's just so interesting to see how these appellate courts come to these different decisions, especially when I shouldn't say I feel like they're sitting there being like, she's guilty, but that doesn't matter. Let's put that aside. And lawyers have the ability to do that. We're trained in how to think and read and the ability to do things like that can be very difficult for your average person. And I get it. That is, defense counsel could have based his challenge on juror M.B.'s relationship to the prosecutor, 1B, or his state of mind resulting from that relationship, which would be 1J. Given the context, we reach two conclusions from the record. First, we conclude that counsel's stated reason, his son-in-law works for Mr. Allen, was sufficient to trigger a ruling under subsection 1B. I tend to agree with that. And again, lawyers don't have to be perfect, right? Lawyers don't memorize every single word to every single statute and every single statute number, but it's like he knew somewhere in the Rolodex of his brain that this is not appropriate and made the objection. Second, even if it were not clear solely from counsel's challenge to juror M.B., on which part of the statute counsel was relying, we nevertheless conclude that the prosecutor and the court's subsequent comments brought section 1B squarely into play for purposes of our review. Talismanic language is not required to preserve arguments for appeal, but the trial court must be presented with opportunity to rule on the issue. So this is like when you say something like, it must be within the third degree of the family. And you're like, well, he didn't say it was within the third degree of the family of the prosecutor, judge. It's like, you don't have to say it exactly like that verbatim. But I'll be honest, I'll just speak for Florida. There are certain things where you have to literally use the exact verbiage, and it's annoying, but it's how it is. As the prosecutor correctly observed at the time of the challenge, neither attorney had asked any questions to elicit whether juror M.B. had a state of mind evincing enmity or bias. Without these questions, there was no way to tell whether juror M.B. should be excused for actual bias under 1610-103-1J. Having recognized this, the prosecutor continued to note the challenge certainly didn't rise to the level of statutory cause. In this context, we conclude the prosecutor could only have been referring to the statutory cause based on bias under subsection 1B, which is the family bias. The trial court's subsequent comments likewise suggest its awareness of the distinct for-cause challenges available under subsections 1B and 1J. The court first said, I don't think it's a statutory cause, and then noted that it didn't hear anything else about the fact creating an issue or conflict or something else. These comments indicate a cursory and improper rejection of a challenge based on the relationship itself under subsection 1B, followed by a separate consideration and rejection of a challenge based on a biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of defense counsel's challenge. Instead, read in context, we conclude the trial court statement, I don't think it's a statutory cause, reflected the court's mistaken belief that juror M.B.'s implied bias based on his relationship to the prosecutor, as distinct from his actual bias as a result of that relationship, did not trigger mandatory removal under section 1610-103-1B. This to me is just confusing. Like, if he has implied bias because of the relationship, why do we even need to get to whether or not he has actual bias because of that relationship? To me, that's not really applicable in the statute the way it's read in this scenario with the elected DA trying the case. In other words, the trial court was not questioning whether defense counsel was making a statutory challenge for cause based on the relationship itself. Instead, and critically, for purposes of our review, we read the trial court's statement as expressing its inclination to deny the challenge for cause on both grounds. And then this is a footnote. The record further supports this reading. In addition to Juror M.B., defense counsel identified Juror 8 among the jurors he wished to challenge for cause. He explained Juror number 8 had indicated on his questionnaire that he could not be fair in this case involving child A, was not sure he could set aside information he had heard about the case, believed a not guilty by reason of insanity plea was a ploy to excuse the alleged crime, and was never asked about any of that. By contrast, when asked for his basis for challenging Juror M.B. for cause, defense counsel simply stated, yeah, his son-in-law works for Mr. Allen. So he wasn't trying to say he was biased like Juror number 8. He was saying he's related to the prosecutor, which is that implied bias. I agree with the appellate court's reading here. When the trial court ruled on the claim raised on appeal, it is properly before us. Defense counsel's subsequent argument that the situation might be different if the juror's son-in-law worked for the police or for a different district attorney other than his direct boss who is trying the case does not change the result. As the Attorney General acknowledges, the argument went to whether Juror M.B. should be excused for actual bias under Section 1610-103-1J, and the trial court had already rejected the challenge under 1B. As a result, defense counsel was under no further obligation to restate his objection. And that, to me, is where some appellate judges might differ. Of how many times we have to restate it and bring it up and protect the record for appeal. Or use a peremptory challenge, or ask for another peremptory challenge if out. Likewise, that defense counsel did not cite 1610-103-1B is of no moment. And I agree with that. You don't have to actually cite the rule, I would hope. The Attorney General relies on People versus Savelos-Acosta, in which a division of this court denied to consider the denial of a challenge for cause because defense counsel did not specifically cite Section 1610-103-1K. But in that case, defense counsel moved to challenge a juror for cause because he would place authority on the testimony of a police officer over anybody else, not based on the mere existence of a relationship covered by the statute. And appellate judges are great at distinguishing cases or comparing cases on how they're the same, right? And when you can distinguish it, this is when I've worked on a couple appellate cases, mostly with my dad or Pete or somebody in the office. I have not done a ton of appellate work myself. I did it in law school as part of moot court when I was on the moot court team, and I loved distinguishing cases and comparing cases. But as a real lawyer, I find it a little more tedious and boring to do it in written form. I'm much more accustomed to and like doing it in oral form at trial. Defense counsel's initial, during motion practice, I'm talking about cases. Defense counsel's initial challenge for cause succinctly stated that Juror M.B. was related to the prosecutor. Unlike Savelos-Acosta, counsel did not argue that Juror M.B. might have actual bias in favor of the prosecution. And as discussed, even if defense counsel's comments left any doubt, the prosecutor and trial court expressly acknowledged and dismissed the possibility of a statutory challenge based on the relationship itself. On these facts, we conclude the trial court was on notice of the particular ground for the challenge, each specific reference section 1610-103-1B. In this case, said an argument that goes to the subject matter of a statute without citing that statute directly sufficiently preserves the matter for appeal. The challenge for cause was preserved even though it was not expressly for cause, because the context made clear it was a challenge for cause. The error was neither waived nor invited. Waiver is the relinquishment of a known right or privilege. We indulge every reasonable presumption against it. Invited error, by contrast, prevents a party from complaining on appeal of an error that the party invited or injected into the case. This is like when somebody says, do you think they're trying to create an appellate issue? Are they trying to create a mistrial? You can't win on an issue you create. It is a narrow doctrine that applies to errors in trial strategy, but not to errors that result from oversight. The Attorney General asserts that defense counsel waived or invited the trial court's error by failing to clarify the basis of the challenge after the ruling, suggesting that the court was confused about the grounds for the challenge. But we have already concluded that the trial court's comments did not indicate that it misunderstood the nature of the challenge for cause, only that it did not believe excusal was warranted. Given this reading of the record, the foundation of the Attorney General's waiver invited error argument collapses. In any event, even after Juror M.B. answered the trial court's follow-up questions, defense counsel said, I maintain my objection to Juror M.B. This ongoing objection suggests there was no waiver. Nor can we conclude that defense counsel waived or invited error by failing to use a preemptory challenge to excuse Juror M.B. The law does not require criminal defendants to use preemptory challenges to preserve an unsuccessful challenge for cause. To the contrary, the Supreme Court has held that its prior decisions do not require a defendant to cure a trial court's error on a challenge for cause by using a preemptory strike against the objectionable juror in order to preserve the claim that his right to a fair trial was violated by the presence of a biased juror. So to me, That's going to be the interesting part about what the dissenting opinion says about that. Whether or not, like, what are all the hoops lawyers have to jump through? Because any hoop I've ever heard of when it comes to jury selection, I try to jump through it, if I'm being honest. Like, in an abundance of caution. Because I've seen so many ticky-tack things blow your opportunity to appeal a very real issue. The holding in Morrison indicates that there is no inherent inconsistency in allowing counsel to challenge a juror for cause while also permitting her to use a preemptory challenge to excuse other jurors. We recognize that the majority in Abu Natambu L declined to answer whether waived or invited error might apply in a situation because it is not raised on appeal. Nevertheless, the majority suggested, albeit in dicta, that even if it were to entertain an invited error argument, it would find no invited error because the record did not suggest that defense counsel purposely failed to use a preemptory challenge to remove the implied biased juror. So now we're throwing in words like purposely. That in order to say defense counsel waived it, they have to purposely, strategically be like, ooh, okay. Like I said earlier, we're going to put this appellate argument as an ace up our sleeve. As long as they don't do that, it seems like this court believes that's okay. Similarly, we see no suggestion of invited error here. And particularly in light of defense counsel's ongoing objection, we see no suggestion of waiver on the record. The Attorney General relies on Justice Samor's dissent in Abu Natambu L, expressing that defense counsel's decision not to use a preemptory challenge to excuse a juror after the loss of a for-cause challenge is a classic example of waiver or invited error. And it is something we see a lot. If defense counsel doesn't do X, Y, or Z, it's like, sorry, you waived. Like Justice Samor, the Attorney General suggests that counsel may simply request and the trial courts may be encouraged to grant an additional preemptory challenge, like we've talked about so many times in so many different cases. But as in Abu Natambu L, the record here lacks any indication that defense counsel was acting strategically, finding no invited error under the same circumstances. Additionally, but how would you find that? How would you know what's going on in defense counsel's head? That's what makes this difficult. Additionally, we are not persuaded that defense counsel should be required to use a preemptory challenge to excuse a biased juror after the court erroneously denies a for-cause challenge. Moreover, nothing prevents the prosecution from using a preemptory challenge to remove a juror who should have been excused for cause. Nor are we persuaded that defense counsel may re-level the playing field simply by requesting an additional preemptory challenge. Our Supreme Court has recognized the type of error implicated here, a violation of the defendant's right to an unbiased jury, as so harmful that it warrants automatic reversal. Structural errors require automatic reversal without individualized analysis of how the error impairs the reliability of the judgment and conviction. The harm arising from a biased adjudicator pervades and infects the entire framework of the trial. And because maintaining the integrity of the judicial process is in the interest of not only of the accused but of the public, we are not inclined to infer a waiver from defense counsel's failure to use a preemptory challenge to correct the trial court's error. So this is where it could have gone either way. I agree with the appellate court. I think they did the right thing for the integrity, for the interest of justice, to make sure this was done right. But this would have been where it turned. And I think, I haven't read the dissenting opinion, that's where the dissenting opinion is going to disagree. So reversal is required. When the trial court erroneously denies a for-cause to a biased juror, the defendant exhausts her preemptory challenges and the biased juror serves on the jury, the error is structural. The result of the legislature's determination that certain relationships render a potential juror implied bias is that the juror is deemed as a matter of law to be biased, period. Such is the case here. Accordingly, Stauch's conviction must be reversed. Brutal, but I agree with it. I want the interest of justice to be preserved. Where was the footnote? Let's read the footnote. Although Justice Samor's dissent suggests that encouraging judges to grant requests for additional preemptory challenges under Criminal Procedure 24D3 would re-level the playing field, we are not so sure. After all, defense counsel would necessarily premise a request for additional preemptory challenges on the court's prior wrongly denied challenge for cause, rulings made by the same judge, and we are not confident that the same judge would grant additional preemptory strikes on that basis. So it's like, I get it, and this is kind of the thing where like lawyers do lawyer stuff, where it's like, well, if we do this, it'll make it more fair. But it's like, in reality, if the judge thought this juror should be gone, he could have just struck him already. So if the defense counsel just asks for a different way to strike the juror, which is an additional preemptory challenge, which the judge doesn't have to do, but has discretion to do, what makes you think the judge would make a different decision than what he just made about the same juror? You get what I'm saying? What's the difference between being like, it's close, let's strike him for cause, versus, it's close, I'll give you an additional preemptory challenge? It's two tools. It's two different hammers to hit the same nail. Whatever. That was probably a wrong analogy, but you get what I'm saying. All right. We're going to skip the search warrant. Additional facts. There a written dissenting opinion, discussion, disposition. All right, here we go. Concurring in part, dissenting in part. Assume a court erroneously denies a defendant's challenge for cause to a hypothetical juror A. Then assume the court also denies defendant's challenges for cause on hypothetical jurors B, C, D, E, F, G, and H. Next, assume the defendant has 16 peremptories. She uses 7 of those peremptory challenges to remove jurors B, C, D, E, F, and G, and H from the jury, and the other 9 to remove prospective jurors who she did not challenge for cause. But she did not remove juror A, who sits on the jury ultimately convicts her. In this situation, does she waive her right to contend she is entitled to a new trial because of the court's error? I would answer this question, yes. Because the majority answers this question, no, I respectfully dissent from the portion of Part 2C3 of the majority's opinion, concluding defendant Letecia Stauch did not waive the error the trial court made when it denied her challenge for cause to Juror M.B. So basically, I think what this judge is saying, and we'll get more into it, is they did use some preemptory challenges on people they wanted to strike for cause, and then some that they didn't even try to strike for cause. So therefore, they chose to allow this juror to stay on, or they strategically wanted this appellate decision. It seems like that's what this judge thinks or is saying. I concur with the majority's determination on Part 2C3 that the court erred when it denied the challenge with the majority's analysis of the Fourth Amendment issue in Part 3C. Okay. I also addressed the issue the majority does not discuss, that the trial court error when it allowed the prosecution to present evidence concerning defendant's prior manipulative behavior. We don't need to get into that. All right, here we go. The interplay of challenges for cause, preemptory challenges, and the waiver doctrine. Waiver. Structural errors, even those impinging on fundamental constitutional rights, can be waived. A defendant can waive her right to a public trial. Her right to challenge a prospective juror who was the wife of the judge presiding over her case, and her right to object to a judge presiding over her case who had, while working as a public defender, previously represented her. And by pleading guilty, she waives a number of constitutional rights, including some that could lead to structural error if erroneously denied, such as the right to a trial by jury and to a public trial. Waiver is the intentional relinquishment of a known right. Intentional. You have to do it on purpose. And that's really how it should be. That's really how it should be. Waivers may be explicit when, for example, a party expressly abandons an existing right. Waivers may be implied when a party engages in conduct that manifests an intent to relinquish a right or acts inconsistently with its assertion. When deciding whether a waiver is implied, the record need only show that a defendant or her counsel made a conscious decision to forego raising a claim or an objection for strategic or other reasons. We do not presume acquiescence in the loss of fundamental constitutional rights, and we therefore indulge every reasonable presumption against waiver. A short history of preemptory challenges in Colorado. The United States Supreme Court has long recognized that preemptory challenges are auxiliary, unlike the right to an impartial jury guaranteed by the Sixth Amendment. Preemptory challenges are not of federal constitutional dimension. If a defendant is tried before a qualified jury composed of individuals not challenged for cause, the loss of a preemptory challenge due to the state court's good faith error is not a matter of federal constitutional concern. Interesting. And it's true, it's because cause is people that absolutely should never be on a jury. Preemptory is kind of like preference. The way Colorado courts view preemptory challenges has changed significantly over the last quarter century. Before 2014, our Supreme Court required the reversal of any criminal conviction which the defendant used a preemptory challenge to remove a prospective juror following an erroneous denial of her challenge for cause, and ultimately exhausted all preemptory challenges available to her. In 2000, the Supreme Court expanded the scope of this automatic reversal rule to include the erroneous grant of prosecution challenges for cause, reasoning that such error gave the prosecution an unfair tactical advantage. But in Novotny, our Supreme Court abandoned the automatic reversal rule because both federal and state law governing harmless error review in general and the lack of constitutional significance of preemptory challenges in particular have developed so as to substantially erode the premises upon which the automatic reversal rule rested. I mean, I hate this discussion because peremptory challenges are so incredibly important, because there are certain things that aren't statutory that are like seem super obvious to us on one side, but maybe not the judge. And as you can see, the other lawyer on the other side is never going to just allow us to strike a juror that is obviously bad for us sometimes. So I don't like, lessening the importance of peremptory challenges. The court replaced the automatic reversal rule with an outcome determinative rule based on the harmless error standard of Criminal Procedure 52A. An error will be disregarded unless it affects substantial rights, which requires evaluating the likelihood that the outcome of the proceeding in question were affected by the error. Under the harmless error standard, if a juror biased against the defendant sits on the jury, such an error is structural because it violates a defendant's right to an impartial jury, and the appellate court must therefore reverse the defendant's conviction. The majority in Novotny did not address the scenario we face in this case. So he's saying, like, this isn't a question that hasn't been answered in that case. Does a defendant waive the error if she uses all her preemptory challenges, but she does not use one of them to remove a juror whom she challenged for cause and didn't ask for another one? I think that's important. And the trial court erroneously denied that challenge. I will discuss this issue next. Preemptory challenges and waivers. The issue some might say that at least under federal, the issue in this case has already been decided by the United States Supreme Court. In Martinez-Salazar, the government urged the Supreme Court to read federal law to require a defendant to use a preemptory challenge to strike a juror who should have been removed for cause in order to preserve the claim that the for-cause ruling impaired the defendant's right to a fair trial. The Supreme Court rejected this invitation, reasoning there was no federal law demanding that a defendant use or refrain from using a preemptory challenge on a particular basis or when a particular set of facts is present. The court recognized that there is one obvious exception to this statement. The Equal Protection Clause clauses prohibition of exercising a preemptory challenge to remove a potential juror solely based on the juror's gender, ethnic origin, or race. This language some would suggest shows the United States Supreme Court rejected the application of the waiver doctrine to situations such as the one in this case. But I submit there are three reasons in Martinez-Salazar why Martinez-Salazar did not do so. First, the language is dicta. Second, in a concurring opinion, Justice Scalia pointed out the issue before the Supreme Court was not whether a defendant should be required to use a preemptory challenge curatively when a trial court has erroneously denied a cause for challenge. Rather, the issue was whether a defendant's actual use of a preemptory challenge to effect such a cure impinged upon his ability to exercise all his preemptory challenges under Federal Rule of Criminal Procedure 24B, and the majority had concluded the exercise of the defendant's preemptory challenges had not been adversely affected. Justice Scalia was far from certain that the court's analysis of the use of preemptory challenges was correct. It is easy enough to agree, he continued, that we have no warrant to read into Federal Rule of Criminal Procedure 24B a requirement that preemptory be used to remove veneremen properly challenged for cause. The difficult question, however, is not whether Rule 24B requires exercise preemptory challenge, but normal principles of waiver disable a defendant from objecting on appeal to seating of a jury he was entirely able to prevent. This is confusing and kind of like picking and choosing and cutting it together. Generally, all the same principles are applying. If this person was so bad, you should have used a preemptory challenge, and if you didn't, did you waive the right to argue this on appeal? That's basically what they're saying, and that's what it's boiling down to. Then he added, I would not find it easy to overturn a conviction where, to take an extreme example, a defendant had plenty of preemptories left, but chose instead to allow to be placed on a jury a person to whom he had registered an objection for cause and whose presence he believed would nullify a conviction. So if they didn't use all their preemptories, okay, that's what Scalia is saying. Third, Martinez-Salazar concerned a rule of federal criminal procedure, not a rule of state criminal procedure. While Martinez-Salazar is the law in cases involving federal criminal procedure, is not the law that requires any change of course from this court. The part of Martinez-Salazar pertinent to this case is not based on any legal principle that applies to the states. Martinez-Salazar may have left open the issue of whether, under federal law, normal principles of waiver disable a defendant from objecting on appeal to the seating of a juror he was entirely able to prevent through the use of preemptory challenges. That case is not binding upon state courts. In other words, it does not set out a constitutional rule controlling state court. There is a potential Colorado counterpoint to Martinez-Salazar. Shortly before Martinez-Salazar came out, a division of this court decided People v. Morrison. The division concluded, because the defendant chose not to excuse the juror in question by use of a peremptory challenge, the court's denial of his challenge for cause did not have the effect of reducing the number of peremptory challenges that he could exercise. As a result, the defendant failed to demonstrate how the court's denial of his challenge worked any prejudice upon him. If it was so bad, why didn't you use a peremptory challenge? So you're seeing all the different cases basically saying the same thing, the same principles we've been discussing. About 5 months after Martinez-Salazar was decided, our Supreme Court affirmed the division's decision in Morrison v. People, albeit on different grounds. The Supreme Court's opinion unspooled like this: we hold the trial court did not abuse its discretion in denying the defendant's challenge for cause because the juror in question stated that she could fairly hear the evidence. Because the trial court did not commit any error concerning this juror, we need not base our decision on how the defendant responded to what he perceived to be erroneous denial of a challenge for cause. We consequently find it unnecessary to determine whether a defendant suffers an impairment of his right to use a peremptory challenge if he exhausts his peremptory challenge but does not use one of his challenges against a juror who he originally challenged for cause. So one thing I'm noticing in this dissenting opinion that they're kind of ignoring, which I don't know how much more we have left, but he's not really focusing on the fact that it was the family part of it, the B part of the statute. Regardless of whether the defendant chose to use a peremptory challenge on the allegedly objectionable juror, because he challenged the juror for cause and she served on the jury, his right to an impartial jury was violated if his challenge for cause was improperly denied. The opinion proceeded to discuss whether the record showed the trial court had erred when it denied the defendant's challenge for cause, ultimately concluding that the trial court had not erred. Fast forward 19 years to Abu Natambu L., which the trial court erroneously denied a challenge for cause based on section 1610-103-1K. The majority described the issue in that case as follows: what standard of reversal applies where a trial court erroneously denies a challenge for cause? The defendant exhausts his peremptory challenges and the challenged juror ultimately serves on the jury. The majority answered the question this way: we conclude that the erroneous seating of an implied biased juror is structural error and requires reversal. As a result, such an error is not admissible to analysis under harmless error standard, regardless of the juror's actual bias. The majority did not address the issue as whether the waiver doctrine applied in those circumstances because the prosecution had not raised the issue. That's always the other part about appellate law. It's like, if we don't have to answer it, we're not going to answer it. Justice Samore dissented. After arguing that the juror was biased and should not be allowed to serve, Justice Samore wrote, the defendant turned around and elected not to excuse her with one of his 12 peremptory challenges. As a result, Samore thought the defendant had either waived or invited the error. So this judge agrees with Samore in that case. But Justice Samore asked, would one unfair shortcoming of his approach be defendants always losing? Had this covered, encouraging trial court judges to grant defendants' requests for additional peremptory challenges under criminal procedure 24D3. Here's the other thing though. If you tried a bunch for cause, you got some and not others, you struck some with peremptory challenges and then others that were not struck under cause, would a judge grant you another one really to strike somebody for cause when you could have used the other one, the same analysis here? Because I kind of think the judge would say the same thing here. It's like, you had all these peremptory challenges. You could have struck all your cause jurors and you didn't. Whenever they deny a colorable challenge for cause, i.e. one that is difficult to resolve and presents a close call. Analysis. I conclude for the foregoing reasons that the defendant waived the error the trial court made when it denied her challenge for cause to Juror M.B. She waived the error because she did not remove Juror M.B. with a peremptory challenge, although she had 16 available to use for that purpose. I wonder why that nobody said anything here about asking for another one. The issue is preserved. The prosecution raised the issue on waiver in the answer brief in this appeal. This is basically heads up. If you want to appeal it up to a higher court, the issue is preserved and you can do that. And I think you actually should win. The issue has not been decided in Colorado. Martinez-Salazar only applies to federal cases. Morrison did not resolve the issue either. The Supreme Court stated it need not base its decision on how the defendant responded. So basically you're saying this hasn't been decided before. The court said it's unnecessary to determine whether a defendant suffers an impairment of his right to use a peremptory challenge if he exhausts his peremptory challenges, but does not use one of his challenges against a juror he originally challenged for cause. Our Supreme Court resolved the appeal by concluding the trial court had not erred when it denied the defendant's challenge for cause. Harkening back to Scalia, and Morrison not requiring a defendant to secure a judge's error on challenge for cause by using a peremptory challenge was dicta, meaning it was not something that they have to follow. It was kind of discussion. They were just kind of discussing it. It wasn't the rule of law that is now binding. And in Abu Natambu L, our Supreme Court stated that this issue has not yet been decided. I am aware of the division in People v. Garcia stated in Morrison's holding was, in part, that its previous decision to not require a defendant to cure a trial judge's error on a challenge for cause by using a preemptory strike against the objectionable juror in order to preserve a claim that his right to a fair trial was violated by the presence of a biased juror on a jury. Here's the thing. I don't think a higher court is going to want to make this the case that you really overturn and allow somebody whose son-in-law literally works for the guy that is his boss in trying this case. That's the problem. It just looks so bad. But I think the division put more weight on the quoted language in Morrison than the language bears because it was dicta. In any event, I am not bound to follow the Morrison division's reasoning. One division of the Court of Appeals is not bound by the decision of another division. I will say, it's also easier to agree with the other courts than to disagree, and he's disagreeing with a couple of the courts, but he's saying they didn't decide it fully. Requiring parties to use a preemptory challenge to cure jury selection errors is a good idea whose time has come in Colorado. Okay, so this is them just basically making the argument that Colorado should basically say you have to use a preemptory challenge to cure jury selection errors. I totally disagree with this. I think when it comes to preemptory challenge, you have to strike the people that you think are the absolute worst. And if later you find out the judge screwed up by not striking a cause challenge, I do think you should be allowed to make this argument. I don't have time to read through all of this as it applies to Colorado law today. But if you guys do read it and you have thoughts on it, let me know. And let me know what you think about that. Do you think a defendant should have to cure all the judge's issues? Or if he tries and the judge still has an error and he strikes somebody else for strategic reasons, meaning like that person was so bad, but the judge wouldn't strike them. Or let's say you only have 5 challenges and you tried to get 6 people off for cause and you strike 5 of them and there's one more. Like, what's the issue there? And how much of the onus should be put on the defendant versus the prosecutor and the judge who should do the right thing and follow the statute? And if they screw up and create an unfair trial, like the defendant should get a fair trial, even if it's Letecia Stauch. And I know that's hard to hear and hard to swallow. Whew, that was a lot. All right, let me know what you guys think. Please take a second and subscribe if you haven't already. We'll see if this trial happens again. If it does and you guys want me to follow it, let me know in the comments. Make sure you hit that like button. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.